Welcome to the first in our series on Untangling the Challenges of Aging, Vital Decisions. Thank you for joining us today. I am Cheryl Sodorf with Willamette Valley Hospice and Palliative Care and the moderator of today's session, Critical Legal Tools as You Age, featuring Stephanie Pomblad, attorney at law with Collier Law Firm. And I would like to give a very special thank you to our sponsors who have made this possible for all of us. Thank you to Collier Law, who is our title sponsor, and our corporate sponsors, Salem Health, Oregon Oncology, Caldwell Banker Commercial, Mountain West Real Estate, and Norco Medical. Our webinar series is free for all 3 sessions, which includes today. You may register for the other sessions and invite friends and family to participate. Any donations given will be accepted and go to our community bereavement programs. Visit wvh.org for more information on all of our programs, and in particular this series, Untangling the Challenges of Aging, Vital Decisions. Questions will be answered at the end of the presentation, and any that do not get answered due to time will be addressed via email to you. So it's critically important that you use the chat box to the right of your screen and you put your name after your question and your email address, so we will know who that question belongs to. And you may have more than one question. Please put your name after each question that you might enter. And now I'm very excited and pleased to introduce to you our presenter today. Welcome to Stephanie. We are so glad to have you and appreciative of your time.
Well, thank you. My goal for you today is to familiarize you with the situations that you or your loved one might come up against and which tools you might want to put in place in advance to confront those situations with confidence. Now, names and details have been changed to protect the innocent, but these are very real situations that I am helping people with regularly. Often people come to us in times of transition, so each family we discuss today will focus on a transition time in their lives. Now, as we get started, I want to start with some foundational information, and that is what are the core concepts in estate planning? And for me, there are 3. First is on the medical front. So who would handle medical decisions for you if you cannot speak for yourself? On the financial front, who would handle those financial or legal affairs for you if you could not speak for yourself? And finally, on your passing, who will be in charge of carrying out your wishes and who will receive your assets at that time? So as we talk through, these are really the core concepts that we're going to be working with today. One thing that people often ask me is, well, when is the right time? When should I start estate planning? At what point am I ready? Is it when I retire? Is it when I've hit the lottery? What is the right time? And really the answer is when you're an adult. Once you hit age 18, no one can make medical decisions for you without your written consent. No one can handle your finances without your written consent, and HIPAA laws protect medical records of an adult. So, for parents out there who have somebody approaching 18, they may still be in high school, but that doesn't mean that you have those additional legal rights. Once they become an adult, it's time to start talking. So as we start talking, I want to start with Jane. Now, Jane's transition point was she was turning 30 and she had just finished settling her father's probate estate. She lost her father unexpectedly. Now, she's an RN. She's a busy lady. She's married. She doesn't have any kids. But when her father passed, the family was not prepared for it at all. He had no estate planning documents in place. Now, her parents were divorced. They had divorced some time ago. Her mother lives in Washington, and her father had a long-term partner. They'd been together over 10 years, and Faye was his partner. They were not married, and he was the one who was the owner of the house that he and Faye had been living in for the last 10 years. Now, she had to deal with probate. So what is probate? People talk about probate and avoiding probate, but what does that mean? Probate is the court-supervised transfer of titled assets from someone who has passed away to the people who will eventually receive those assets. In Oregon, personal representative is the term that we use, and that is the person appointed to settle the estate. Some states use the term executor or administrator, but Oregon uses personal representative. The creditors are notified and filed, taxes are filed. The will, if there is a will, is your final instructions to the probate court regarding who should handle your affairs and who's going to receive your assets on your passing. It often waives the requirement of bond. Otherwise, bond is generally required. So what is bond? What does that mean? Bond is like an insurance policy for the estate to protect those assets for the creditors and the heirs in case the personal representative makes a mistake or walks away with those assets. So in this case, in Jane's case, her father did not have a will. So Faye, she was not his spouse, and she had no legal right to serve as personal representative and settle his estate, even though she had been with him for over 10 years. Now, originally, they planned on having Jane's older brother serve, but he was not approved for bond because he had a recent bankruptcy. And when an insurance policy is going to be issued to protect those assets, they want to know whether they will be insuring somebody who is creditworthy. And so they'll pull credit and they'll look at that in making a decision on whether to issue that bond. So her brother was not a good candidate because he couldn't be bonded. So instead, Jane got the job, and she had to collect signatures from her siblings agreeing to have her serve. Now, again, because there was no will, some Oregon defaults applied. And Oregon law says that if somebody is not married, but they have children, then their estate passes to their children. And in this case, her father had 3 kids, and there was no protection for Faye, his significant other. She receives nothing under Oregon law because she's not his spouse. Now, Jane has a younger brother. He lives with her mom up in Washington. He does not have a job. He's not going to school, and money just flows through his hands like water. He is entitled to 1/3 of the estate as one of the 3 children. Now, this was a problem because we've got Faye living in the house that they've been in for 10 years. This is her home. Well, her younger brother wanted his share in cash as soon as possible. And even though Faye and her older brother, or Jane and her older brother, were on board with allowing Faye to stay in the house, their younger brother wouldn't agree to it. So the house had to be liquidated. It had to be sold so that they could pay out their youngest brother his share of the estate. And it was just heartbreaking for Jane to watch Faye be left in that difficult financial position. And Jane and her older brother ended up actually helping Faye financially as she transitioned out of that home that she had lived in and loved for the last decade. So it was a really challenging situation. And honestly, Jane was angry at her father for failing to put a plan in place. So Jane was ready to put her own plan in place, and she had a lot of strong feelings about what she did and did not want in her planning. She knew she did not want to be involved in the probate court again. So when she put her estate plan together, a trust was the tool that was most important to her. Now, a trust is designed to bypass probate court altogether. She wanted to ensure that she chose the person who would settle her estate and a few backups just in case her first choice was not available. She wanted clear instructions on exactly who would and would not receive her assets. And she wanted her estate settled as quickly, efficiently, and privately as possible. So she put a revocable living trust in place to accomplish those goals. Now, one thing that's important to know about a trust is that an empty trust can do more harm than good. When I talk about a trust, generally I say it's like a bucket. It's just an empty structure you create to control your assets, but it only controls the assets inside of it. So we need to make sure that we are connecting those assets to the trust. And funding is the word we use when we talk about the process of connecting those assets up to the trust. So for a home, we might retitle that to you as your trustee of your trust. For your bank accounts, checking and saving, we might retitle those accounts so that you own them as trustee of your trust. So that's how we get those in the bucket. Some assets, we update the beneficiary designation. So for your life insurance, we might say it's yours during your lifetime, but on your death, the beneficiary, the payout will come into that trust. There are some exceptions to that. Retirement accounts are an example of an asset that we handle a little bit differently. But in our case, our office, we provide an itemized list of instructions for how our clients should handle every single type of asset they specifically have. But you need to be aware that if you have a trust, if all the assets are not updated to line up with the plan, there is a risk that a loose asset could trigger probate. And in Jane's case, the whole point of her plan is to avoid probate. So we wanted to be sure that everything was properly funded. Now, the other thing that's important for Jane is that she's married and she can take advantage of certain tax exemptions. So for her, it was important for her to consider tax planning. Now, I'm going to walk you through an example of how tax planning might work. And I'm going to use $2 million as the example because it's tidy for my math. But for a couple who has $2 million in assets, when the second spouse passes, assuming no planning is done at all, then the tax bill might be $100,000 to $160,000. So this is a tool that we might put in place to reduce that tax bill to zero. If they had $2 million, when the first spouse passes, we want to divide the assets. So I'm going to say Jane's husband passes away. He passes, then his half gets set aside. It's going to go into a separate account and be completely set aside. And Jane's half of the assets will stay with her and they will be under her control. Now, her husband's share of the assets would be locked in. What does that mean? Well, that means that they are available for Jane for the rest of her life for her health, education, maintaining and supporting her normal standard of living, but she can't pull all the cash out and blow it in Vegas. She couldn't go on a hot air balloon trip around the world. She wouldn't be able to do those types of things. But if she needs to replace the roof on her house, if she's taking care of her routine expenses, replacing vehicles, moving from one home to a similar home, or even downsizing, maintaining that normal standard of living that she was accustomed to during her lifetime, that money is available for exactly that purpose. So by splitting the money, what we can do in Oregon is we take advantage of their exemption. Oregon's exemption is set at $1 million. So when her husband passed, that locked trust would capture his exemption, his $1 million exemption. And when Jane passes away down the road, that purple bucket on the right there, that represents what Jane would still need to report for tax purposes. She would say, I still have $1 million to my name, and she would use her $1 million exemption. So we would be capturing both the first spouse's exemption and the second spouse's exemption. So there would be no additional assets that would be taxed under this plan. So this would zero out their tax bill. Now, one other thing that's really important is for Jane, she's still pretty young. She will need regular reviews. I like to check in about every 2 years, but her finances are likely to shift. She may move, she may change jobs, she may change retirement accounts or have multiple retirement accounts as she moves through her career. So we really want to make sure that her documents are aging well and her assets stay connected to the trust as she moves through life. So next I want to talk about Sean. Now, Sean was 45 and he has 2 kids, 7-year-old and a 10-year-old, and he was working part-time in retail, but he really didn't like it. His husband's an accountant and handles all of the household finances, handles all of their investments, deals with the taxes. And he watched his parents go through a bitter divorce involving infidelity. And he saw his mother emerge from that knowing nothing about the household finances, nothing about investments, and dealing with a lot of guilt and shame as a result of not knowing more earlier. So he decided to go back to school himself and he ended up becoming a divorce counselor. But seeing his mother and her lack of knowledge about the finances and seeing her feel helpless made him want to take some control of his own situation and bolster his own financial comfort, confidence, and independence. Now, in Sean's case, he has one sister and his husband's an only child. They did not want to name their aging parents on their documents, and they didn't really have anyone else they felt comfortable leaning on to manage the finances for the kids in the event that Sean's sister couldn't step in. They wanted to ensure their money was managed well for their kids if they're gone. So, depending on asset level, we might look to an institution or an independent fiduciary to step in this type of situation. So, for Sean's case, they wanted to name a professional fiduciary as a backup after Sean's sister to give her the flexibility to step out of that role if she had too much on her own plate, if she had a medical change or couldn't serve for any other reason, she would have a backup in place, and it was somebody that Sean and his husband chose. Now, let's talk a little bit about children. I want to start first on discussing minor children. Now, I have a 1-year-old and a 4-year-old, and they are action-packed kids. And one of the things that's important as we think about minor children is all of the things that we hold in our head for them. Now, I have hopes and dreams and wishes for my kids, places for them to go, books I want them to read, experiences I want to be sure they have, foods I want to be sure they try. So guardian guidelines are a great way to give some information, whether it's to your children or the person who would raise your children, if you couldn't do that, to help them understand all of the things that you hold dear to you for them. The other tool to consider is a pooled trust. So when you think about how you parent, if you have kids, you know that they're not all the same and they have uneven needs. You might have one child who has a lot more financial needs because they need a lot of tutoring. They're really struggling. They're dealing with dyslexia or something else is going on, that there's going to be more cost with that child for supporting them. Or you might have another child who is extremely skilled athlete and you need to spend more on them getting them to competitions or buying them supplies for that sport. Kids have different needs. So one tool we might look to for minor children is called a pooled trust. So it holds the funds in one pool of money until the youngest child hits 21. And at that point, then whatever's left gets split 50-50. So it reflects how we parent, how our children may have unequal needs. And those assets are just available as a pool to support the kids when they're young. And once they get older, that's when we actually split it out and talk about what they each will receive. And kids age. So as you think about those aging children going through those educational years and kind of entering adulthood and a career, we want to be sure that we're sharing those values if you can't be there to share them yourself. So for Sean, seeing his parents' seemingly rock solid marriage crumble really shook him. So after going back to school, Sean saw education change his individual financial situation. He became more comfortable, more confident financially, and he felt more secure for that possibility of weathering an unexpected storm. It was really important for him to ensure that their children had educational incentives, motivation to complete higher education, even if their parents weren't there to incentivize them. So for them, we talked about maybe a direct cash gift on completion of a bachelor's or a master's degree. Or what about a cash gift for each semester that they made a GPA requirement that he likes? And we can't always assume that every child will go through a traditional 4-year bachelor's degree program. What about trade school? What other opportunities can we incentivize them to complete to make sure that whatever road they walk, they are equipped to thrive? The other tool we can put in place and did put in place for Sean is lifetime asset protection trusts. So really divorce is at the forefront of his mind right now. And as he looks at his kids who are still young, he is seeing in their future the risks of divorce, bankruptcy, lawsuits, judgments, foreclosures. He doesn't know what's coming, but whatever he gives them, he wants to protect. So an asset protection trust that lasts for their lifetime is a great tool to give them protection they could not give themselves. So in their case, we're going to use that same standard we talked about in the spousal trust: health, education, maintenance, and support. That money is going to be there for the kids to support their health needs, their educational journey, and maintain and support their normal standard of living as they start life. In their case, he has their aunt, his sister, lined up as trustee. At age 25, the kids can come on board as a co-signer on the trust, but she's going to continue to be there with them as a safety net, as a co-signer on the trust. At age 35, then she's going to drop off and the kids will handle things going forward alone. And, as you think about this possibility, sometimes people forget about how much their kids could inherit, especially if they're young kids, if you have life insurance. Young parents often do carry life insurance because of the risk that if something happened, there would need to be a lot of support for those kids. So it's important to think through the what ifs and what could come, what could your child inherit if something happened, and make sure that whatever that plan is, it's well suited to support them thriving in that environment. And the reality is, as it turns out, some children never really mature. So we often put together plans with higher age thresholds. I've seen people choose 55 as the age at which their child will get access to signing authority on their trust. And in some cases, parents choose not to have their kids manage their own inheritance. They want a gatekeeper on that money to make sure that that money is protected and used wisely for their children. Now, this is Mary. She was 16, getting ready to retire, forward thinking. She has 3 adult kids. Only one of them lives nearby, but she's healthy. She loves her job. She's just kind of forward thinking at retirement. She and her husband had prepared documents when the kids were young. At that point, they listed their siblings in all of the key roles. But her husband passed several years ago, and there was no rush to update documents at that time. She already knew her sister was her primary. She had a backup in place. Even though her husband had passed off, she had those people lined up as second and third already. But now it was time. It was time to bring the kids on as those backups and have her siblings step off of those documents. I really like to include 3 names. So your primary decision maker and then 2 backups. That way, even if something happens to your first person, you have 2 people lined up on the document still. So for Mary, we're going to bring them on the advance directive so that they can make medical decisions for her. We're going to bring them on as financial power of attorney and as successor trustee. And we're going to sign a HIPAA release so that all 3 of her kids have authority to be in the healthcare conversation in a crisis. No one could be excluded. Even though there would be one person who was going to be the first decision maker, all of her kids would be involved in that conversation. Now, it's really important to start the conversation with your family on what to expect. Holidays are a great time to broach that subject. Everyone's together, everybody's in a good mood most of the time, but really any time can be a good time. On the passing of her husband, she saw some bitterness come up between the kids, and she was really surprised at that. She thought they got along well, but there was more mistrust and more disagreement than she expected. So for her, it was really important to have a family meeting where we talked about who is going to serve in which role, what exactly that entails, when and how they would step in, and who the backups were in what order. That way there was no confusion and they could all talk about any concerns at that time. Now, this is something that if you're working with an attorney, you might just ask them, is this something that they include with planning? Because not all attorneys will include that. They may charge extra for that additional meeting. That's generally something that we include in our planning. If somebody wants us to explain the documents to their family and help facilitate that meeting, generally we're happy to do that at no additional cost. But be sure that you ask. Minimizing conflict. Now, personal belongings can be a huge issue. I had a client who passed away and we got the plan in place before her passing, but it was very close. And after she had passed, I sat on her couch and I watched while her kids fought over her personal belongings and had heated arguments over coffee cups and who was going to get which coffee cups. And I was there and I helped them work through that process. But a much better tool to use when you have the time to think these things through in advance is called a personal property memorandum. This is a tool that can reduce conflict between kids or your other beneficiaries by having clear instructions for who gets what. This is the current version, the modern version of having the masking tape on the back of the hutch with John's name written on it. That isn't binding. Tape falls off, names suddenly are different names because somebody else wrote on new masking tape or mom changed her mind. So a better tool that really can reduce that conflict is that personal property memorandum. That is a signed and dated list that you can change at any time, that you keep control over. So this is a great tool to consider when you're thinking about minimizing conflict on passing. Gladys and Jim came at a time of transition where they needed a little bit more help. Now, Jim first came to us back when Gladys had a diagnosis of early onset Alzheimer's, and he came back when her ability to be in the home and his ability to care for her in the home, her Alzheimer's had outpaced them both. So they were looking at moving to a care facility. Now, Jim and Gladys were fortunate because they saw this coming early. Both her mother and her older brother had Alzheimer's, and so at the first whiff of concern, they put a plan in place. And in their case, this was really important to them because they had the family farm, and the family farm was worth about $600,000. It had been in the family since the 40s, and they didn't really have much in the way of cash. They didn't have investments, but they didn't have any debt either. They got by, and they lived within their means. But they knew that if Gladys went into a care facility, they would run out of cash very quickly. So they were forward thinking that they would almost certainly need Medicaid to help pay for her care. Now, the problem is if they use Medicaid to pay for the care, then when both Jim and Gladys pass away, the state can ask for reimbursement of all of those funds spent, which could be hundreds of thousands of dollars and would mean selling off the family farm to repay that debt. So what they put in place is called a Medicaid Asset Protection Trust. And they did this well in advance. When they first started noticing concerning signs, they put their house, the family farm, into a Medicaid Asset Protection Trust and effectively got it out of their names. Because it wasn't in their names, and it had been years, it was about 6 or 7 years before they needed Medicaid, that farm, even though they still lived there, was not counted as one of their assets for the Medicaid application. Now, it's important to know that Medicaid looks back 5 years for any gifts, any assets given away, or anything sold for less than market value, and that could trigger a period of penalty during which you might be ineligible. So it's really important that we get this plan in place in advance so that we clear that 5-year look back window. So putting that Medicaid Asset Protection Trust in place ensured that the family farm was going to be protected for their kids, and they would still be able to apply for Medicaid and get that care that Gladys needed. So that allowed them to continue living at the farm for their lifetime, knowing her care would not force liquidation of that family history. So getting ahead of the diagnosis is really important. Making sure both spouses had the advance directive in place, making sure both spouses had the HIPAA release in place to handle all of those issues that arose. And then choosing financial decision makers. Now, when we put the plan in place for Jim, we were pretty confident that Gladys wouldn't be in a position to be his primary point person. So on Jim's documents, they decided to name their daughter as the first medical and first financial decision maker instead of naming Gladys. And they trusted her to have mom as involved as she could be, depending on her condition at that time. Now, Gladys opted to keep Jim first and named their daughter as the backup to him. But because they only have one child, they had her listed to handle everything, medical decisions, financial decisions. She's there to receive their assets on passing, but they had absolutely no backup plan if something happened to her. So it was really critical for Jim and Gladys to think through the backup plan in case something happened to their daughter and think about who are other trusted people they could list as alternates and what would they do with their assets if something did happen to their daughter. Now, in Jim and Gladys's case, they did get a plan in place in time, but what if they hadn't? What if Gladys hadn't signed any legal documents before she passed that point of no return and lost capacity? Well, if that had been the case, Jim could have asked the court to intervene and grant him authority to handle medical and financial decisions. Generally, the cost for getting that in place will be around $3,000 to $5,000 if it goes smoothly. But if there was fighting that occurred, I've seen those go over $20,000 with fighting. And even if everything goes smoothly, it might still cost $2,000 to $4,000 per year to maintain because there's an ongoing reporting duty back to the court. In addition, you have to submit itemizations of every transaction to the court, which becomes public record. So yes, there is an option. There is a backup plan. We can go to the court through that guardianship and conservatorship proceeding to get authority, but it's really not our first choice. Unfortunately, we were able to avoid that altogether because they did get their plan in place quickly at the first indication of Gladys's condition. Now this is Joan. Joan was 85 and she's in relatively good health, but she was kind of having the same meeting year after year and seeming a little bit unhappy. So she actually worked with her financial advisor to create a personal philosophy statement. And I want to read part of that to you. To expand the ways that I can continue to make the world a better place, to live my best life, to encourage and support others to do the same. Now, Joan had been very blessed, and we were working with some tax planning concerns because her assets were over that $1 million threshold. So she was in a position where she was very financially comfortable and she was able to think about leaving that legacy. So as we talked about taxes, we could also talk about how continuing her charitable giving beyond her passing would support her values, share her values with her family, and reduce the estate taxes due on her passing. So it was really a win on all fronts in that case. We wanted to weave her charitable heart through her documents on 3 levels. So first, instilling the value of charitable work. So we set aside some money for her kids, her grandkids, and her great-grandkids so that if any one of them wanted to work a summer volunteering for a charity, she would pay them an hourly wage. So the charity wouldn't have to pay for that work. She would actually give them a wage for doing charitable work for an organization. So the kids can earn funds during the summer, the charity gets that free work, and it's a win for everybody. Second, we wanted to work with her donor advised fund. So we set that up with the Oregon Community Foundation so that she could think about what assets she wanted to give for the charitable contribution. And then third, we wanted to bring her kids and grandkids into the conversation about giving on her passing. So she wasn't ready for them to be involved in picking charities quite yet, but on her passing, she wanted to get an opportunity to pull them into that process, to let them investigate charities and choose which organizations received grants. So we set it up so that once a year, her kids and grandkids would get together. They would look at a slate of organizations that Oregon Community Foundation put together for them that were looking for grants, and they could pick which opportunities they wanted to support from her funds. Her tax planning can also reflect her charitable passion. So this is an example of one of the charitable planning tools that Joan looked at. And for this part, I'm going to turn my camera off so that the slide is a little bit easier to see. So this is what's called a charitable lead annuity trust. So in her case, we're going to set aside $1 million for charity. Now, $1 million, that seems like a lot. And you might think, well, what is she going to leave her children? A lot of people call this tool a give it twice trust because it provides for charity and it also provides for family. So in this case, we have $1 million set aside for charity, and on her death, that's it. It's locked in. It's happening. For 20 years, that money is going to spin off a gift of 5% each year to her Oregon Community Foundation donor advised fund. Now she's going to leave instructions with the fund encouraging her kids to consider grants for organizations like Gilbert House, Marion Polk Food Share, Family Building Blocks, but ultimately she's giving the kids and grandkids the discretion to choose the recipients that mean the most to them. The immediate deduction, the estate tax deduction for IRS purposes, was not the full million, but almost. She got a very high return on that charitable gift. And assuming 5% annual growth on average over the course of 20 years, the charity would receive a total of about $1 million using only the income on the account. So what happens to the principal? Well, after 20 years, the rest of it goes back to her family. So this is why they call it a give it twice tool, because over the course of 20 years, she has given $1 million to charity, but at the end of 20 years, she has kind of used that time value to give that same gift again to her family. So this is a neat tool that can really support both charity and family. Now, there are 3 questions that I hear a lot, and I want to address them very directly. Will my spouse disinherit my kids from a prior marriage? What if my surviving spouse remarries? What if somebody financially manipulates my spouse after I'm gone? So these issues really focus around one primary concern, and that is, what if my spouse remarries after my passing? This can be a huge concern, especially if we're in a second marriage where you each have your own separate kids. When you're gone, will there be anything to bind your spouse to your children to ensure that your assets will go to your children on your passing? What protections can we put in place for that? But the other side of this is the risk of financial elder abuse. And financial abuse can come from both within the family and from outside the family, but it's almost always someone who knows the victim. So there are tools where we can use to put in place to protect our future selves from this risk, whether it comes from a young new spouse looking to access funds, a family member applying some emotional pressure to get gifts or financial help, or loans that just never seem to get repaid. You probably know somebody who has a family member like that who's just always looking for another dollar. So there are some tools we can put in place to protect in this situation. So I want to come back to the family trust. So protecting your spouse and your beneficiaries both using a family trust. So as a reminder, we talked about that tax split tool. I'm going to kind of refresh your memory on this piece. On the first spouse's passing, we divide the assets. We create the deceased spouse's share, and we create the surviving spouse's share, but they're separated out. The deceased spouse's share is locked, and I want to take a closer look at what does that mean, that locked trust. What does it do? So there's a lot of strategies that we can apply to that trust to make sure that we're protecting your spouse, protecting the kids, protecting everyone. So on the first front, we want to protect the children. We want to make sure that whatever assets are left in that bucket are going to your kids or your joint kids on the spouse's passing, or your charities or your siblings, whoever you have chosen. We want to protect your intent without stripping those assets away from the spouse during their lifetime. So what we can put in place here is a provision that says the spouse has no ability to redirect the funds. The money is there. It's for the deceased spouse for the rest of their life, for their health, education, maintaining and supporting their normal standard of living. But on death of the deceased, on the death of the surviving spouse, they can't redirect this money. It is what it is. Your wishes will bind that money on your passing. We can also include a provision that says if that spouse remarries without a prenup, then the spouse no longer gets to write checks on this account. A trustee that you choose steps in and serves as a gatekeeper for those funds. So this reduces the incentive for someone to marry your spouse in bad faith. And I have to tell you, I've had about 3 couples over the last few years come to see me, and generally it is an older gentleman with his new spouse recently acquired, who is 10 to 30 years younger than him, depending on the situation. I'm not making these numbers up. And he's there because he's made a decision to, instead of giving assets to his kids, give them to his new spouse. So there is a possibility, and what we don't want to do is we don't want to squish love. If somebody finds love after their first spouse is passing, that's wonderful. But this reduces the incentive for someone to marry your surviving spouse in bad faith. The last component here is ensuring that the funds are there for your spouse for the duration of their lifetime. Even if they're not the one controlling the checks, controlling the flow of money, that we have that money there for them for the whole lifetime. And if there are capacity concerns, then the trustee will step in and take over the finances, but for the benefit of only the surviving spouse. So this reduces risk of financial abuse, financial exploitation, and other risks that relate to what happens after the first spouse passes. So these are some great tools that we can put in place. So as we think forward, the world changes. You put a plan in place, but how do you make sure that it's going to stay flexible for the changing world? Well, ultimately, you need to build a relationship with an attorney and regularly be reviewing your plan. You know, I talked back at the beginning about Jane, who's 30. She's putting her plan in place. Think through all of the things that will happen during her lifetime. She may change jobs. She may move states. She may get a divorce. She may remarry. She may have children or grandchildren. She may never have children. She may become passionate about charity. Her favorite charity may close and change. So the world is full of change. We are living in change. So it's important to keep an eye on your plan and make sure that it's either adapting well to that changing environment or modify it if needed to fix it and keep it healthy as you go. You know, for kids, we have well child checkups. You just need to routinely come in and just keep an eye out for any red flags. The same is true with an estate plan. We really want to keep an eye on it. I like to see people about every 2 years to just check in and make sure if there's anything that's changed, we catch it timely. We have 4 attorneys on our team. So I'm at Collier Law, and there's 4 of us attorneys. One thing I want to point out is Jonathan. His practice includes the Medicaid Asset Protection Trusts, also the Veterans Asset Protection Trusts and Veteran Benefit Planning. So if you're interested in learning more about those specific areas, then I recommend connecting with Jonathan in particular. Any questions related to Medicaid, Medicare, qualifying for benefits, things like that, that's going to be Jonathan's wheelhouse. Now, we have 2 office locations. We're primarily in Salem, but we also have an office up in Lake Oswego. So if you're connecting with us and you want to connect at one of those locations, just let us know which one it is. If you do want to connect with us, we are doing primarily telephone and video conferencing for that first meeting so that we're ensuring that we're minimizing risk to everybody involved. So if you have questions, we do offer free consultation. So that's kind of a no risk way to ask questions that don't get answered, but hopefully we'll be able to answer most of those questions for you today. So take the lead. You are here. You're already taking the first step, but it's time. Take an active role, plan for your future, plan for the future of your family, because if you don't, then there are default rules that'll kick in that may be a heck of a lot more complicated or expensive and might lead to results you don't like. So if you're looking for more information, if you want more learning opportunities similar to this one, there's a couple more weeks of this event, so you'll have more chances to learn here. If you visit our website, Collier Law, we're also doing educational workshops from time to time. They're free. They're just an opportunity to be thinking about issues and learning more. So with that, we're going to dive into questions. Now, we will be looking for contact information. So if we don't catch your question today, then you can either reach out to me with additional questions or we can reach out to you if you provide that contact information. All right. So as we turn to that Q&A, one question that was asked is, if we don't have the income of Joan, if we are not in a place where we are bountifully blessed with assets, can we still leave some sort of a legacy? Can we provide for charity? And what I say is I love to see percentages for charities. One of the reasons I really like percentages is no matter what you have on the day you leave this earth, if you're going to give 10% to charity, 10% will be 10% of whatever is there. Whether that ends up growing or reducing, there will be a gift there that flexes with your time. So I love seeing percentages. And if you think about that, if everybody in our community gave 1 to 2% of their assets to charity, can you imagine the power that our charities would have if everybody just thought about them at least some level? You can really do an incredible amount of good with giving. So regardless of your income level, regardless of your assets, consider including something for charity. And as you're thinking about how to make that gift, you might consider making it directly from an IRA or a 401k. Those pre-tax dollars, let's say you give $100,000 from an IRA to your children. Well, they're going to pay taxes on that. So maybe they end up with $75,000 out of that $100,000 because they have to pay income taxes on that money. Well, if you give that same $100,000 IRA to charity, they don't pay income taxes on it. They get the entire $100,000. So giving a gift from your retirement accounts can stretch the power of that gift. What about when people have adopted someone? So sometimes we have parents who aren't parenting the way they should, and they instead end up in a situation where as grandparents they adopt a grandchild. Well, that's a powerful thing, and often we want to provide for those grandchildren as children. So if you have legally adopted a child, then that child is your child, regardless of what they were before. Once you have legally adopted them, they are yours and they will inherit as though they were your child. So if you want to provide for something slightly different for them, then we would want to use a will or a trust to plan around that. But once you've legally adopted, they are yours. They are your child. As a recent widowed spouse, what is the best tax advice you have? So if you have lost a spouse, then if we haven't put that split tool in place before that time, then that's not going to be an option that we'll use at that point. So you have your $1 million exemption. If your assets are over $1 million, then we would probably want to talk about how far over are you? What expenses do we project? Generally, I'm not going to recommend that people start giving away their money to their family members to get them under $1 million, because we just don't know what your needs might be. So I would say look at your finances and see what you have. We might include some charitable giving, which would also give you a deduction, or other tools to reduce that tax. But generally, whatever you have on the day you leave this earth is what will be assessed for taxes. So if it's over $1 million, then whatever's above $1 million is what would be taxed. So either that's going to be making gifts during your lifetime to people or charities, or making gifts to charities on your passing. Those are ways that we can reduce those taxes. What is a pour over will? And does that help with putting assets into the trust? So whenever you sign a trust, there should always be a pour over will. Now, in a perfect world, the pour over will is a piece of paper that will never see the light of day. If everything goes smoothly, it's never going to come out, because the only time that pour over will comes out is if something went wrong. So let's say your house was in your trust and you went through a refinance. And as part of that, the lender pulled your house out of trust to complete the refinance, but they didn't actually put it back in and nobody caught it. Well, now your house is sitting over here outside of trust. And if you pass away before getting that house back into your trust, well, that's a probate asset. It's not in your trust. You're the only name on that house. Then if you're gone, nobody has authority to deal with it. That's when we would have to get out your pour over will, take it to the court, get a personal representative appointed, run the house through probate, and then eventually it would come back to the trust, because that's what the pour over will does. Scoops up your loose assets and pours them back into the trust. but they're going to take a long and expensive way to get there. So hopefully your pour over will would never be needed. It's just going to be there as a safety net. So this question is, my current plan has been in place for several years. Would you review those documents and make suggestions based on age? So yes, for our office, we routinely meet with people who have older documents or who have trusts that they established in another state. Now they've moved to Oregon and they want to check in on how those documents held up under the move. So we, as I mentioned, we do a free initial consultation to just review the documents, figure out what's going on, and make recommendations. You know, I don't like going to the mechanic because I never know what I'm going to pay to find out what's wrong. And then what am I going to pay to fix it on top of that? So I don't like writing a blank check for a mystery dollar amount to be determined. And we don't run our business that way. What we do is we just do a complimentary consultation where I can get under the hood, dig in there, figure out what exactly is going on in your documents, make recommendations, and then you make the decision. Are you going to invest in making those changes, or are you going to walk away with no cost? So that's how we structure our reviews of trust plans. So let's see. If your trust is over 25 years old and a lot has happened since it was drawn up, should you dissolve it or should you rename it? Should you replace your trust with a will instead? So it kind of depends on your situation. What I would do is I would make a fresh assessment. Looking at your assets, looking at what you want to accomplish, what your goals are, what your assets are. Do we want to use a will and plan on probate, or do we want to use a trust and plan to avoid probate? If we want to avoid probate and use a trust, then yeah, we can rework your family trust. We're going to keep the name, but we're going to replace the contents of it. So we'll rewrite the rules in full, but you keep that original name. So a trust once created has a name, it has a date of birth, and it effectively has a social security number, which is your social security number. So your social security number is the tax ID number for the trust. And the date it was signed is effectively its date of birth. So that's the unique identifier for your trust, but you can rewrite the contents. So if we wanted to keep that trust, we would just rework it. If you decided to switch gears and go with a will instead, then you would revoke that trust and dissolve it and pull the assets out of it and just plan on probate and plan on a will. What are some considerations when picking a fiduciary, a trustee? If I was interviewing potential fiduciaries, questions I would ask would be, number one, do you have a minimum asset level that you require? Now, I can tell you banks like Chase Bank are going to have something like $5 million of minimum assets. So they're not going to be a good fit for a lot of people as far as being a professional trustee to settle your estate on your passing. There are local fiduciary companies that work on a smaller scale that just charge by the hour for their work. That's probably going to be a better fit. So is there an asset requirement? Number two, how do they charge? What are they doing? Are they doing a flat rate, a percentage, or are they charging by the hour? Number three, what services do they include? Are they preparing your tax returns, or they are going to hire a CPA? Are they preparing any legal documents, or are they also hiring an attorney? So what services can they do in-house versus what are they going to hire out? And then I would do a meeting and just connect with them. If they're going to settle your assets on your passing, that's one thing. If you're going to instead have them make medical decisions for you, then you need to have a very different level of communication with them. And they may want to check in with you from time to time to just make sure you're still doing well, you still have capacity. So talk to them about how they keep an eye on you and stay in communication with you. If I'm not married, can I make a trust with my partner? You can make a trust with your partner if you're not married. That is permitted. The question would be, are your assets largely joint? If yes, then that might be a good idea. Are your beneficiaries largely joint? If yes, then that might be a good idea. But if you have different assets and you want them to go to different people on your passing, then a joint document might not be the right fit. You might want to have separate trusts in that case, but that would be a possibility of figuring out how to work that so that you could do a trust together. That would certainly be an option. I had a question, how does one find a professional fiduciary? For that, I'm going to send a couple of names privately, but if you have questions about finding a professional fiduciary, let me know a little bit more about you and I can kind of make a recommendation based on that. So I'll be happy to do that. What about 529 plans? Does a 529 plan get connected to the trust? Generally, the answer is no. So 529 plans, I have a 529 plan for my child, then I am the owner of that plan and my child is the beneficiary on that account. But if I die, then I have named a successor owner, and that is my husband. So if I die, then the successor owner takes over ownership of the account. The beneficiary is still going to be the child, but you want a successor owner. So when you're dealing with a 529 plan, you want to either have your spouse or some other responsible adult named as the successor owner to manage that money, but the child would still stay on as a beneficiary. So if you're setting up 529 plans for grandkids, then you might want to name their parent then as the successor owner. So that would be an option. What about guardianship of a minor child? So you can seek guardianship over a minor child if you do not have authority to do that. So one example is if the parents of a minor child are deceased and grandparents are stepping in to manage that grandchild, then they may need that authority. So that's where we're going to the court to file for guardianship. At that point, you let the court know what's the status of the parents. Are they around but unavailable? If so, they're going to need legal notices. If not, have they passed away? What assets, if any, does the child have that might need management? And who should be in charge of that child? And the child will be probably involved in that process to some extent, but then the court would make a decision about whether to give someone authority to then have guardianship over that child. So that is a court supervised process. If you are somebody else who would like recommendations for professional fiduciaries, if you would pop into the comments and leave your contact information, then I'll reach out to those of you who had asked about that and send you some information. So with that, I'm going to pause and hand it back to Cheryl to see if she has any other questions she wants to address. Otherwise, we'll be close to closing out here for you.
That was awesome, Stephanie. So much information. I don't think people can put a price on the amount of information they got today, and all very, very good questions. And if you feel that you still had something additional, again, put your contact information in the chat box quickly, and Stephanie will reach out to you for those legal matters. We will answer the questions that we are able to answer and make sure that those get back to you quickly. So I am very happy at how this went today and how much information you got. I hope you are too. I hope you join us for our future April 22nd and April 29th, the other two vital decision seminars. It'll be well worth your time. They are on Thursday, next Thursday, and Thursday the 29th. Again, it's noon to 1. And please, if you have any concerns about getting someone registered, you can reach out to us at wvh.org, and we will make sure that everybody gets registered. And remember, it is free. Any last comments at all, Stephanie, that you want to address?
Well, I would just say if we didn't get to a question that you had, then reach out. You can give me a call. My number is 503-485-7224. If you want to reach out by email, just drop your email in the chat and I can always reach out to connect with you on those questions. So I appreciate it. Thank you guys for taking the time, for carving out time to tackle this hard topic. This isn't fun stuff. So, treat yourself to something this afternoon to thank yourself for doing that hard work.
You did awesome. And let's don't forget our sponsors who made this possible and the other 2 sessions coming up possible. And that is Collier Law as the title sponsor, our corporate sponsors, Salem Health, Oregon Oncology, Caldwell Banker Commercial, Mountain West Real Estate, and Norco. Thank you for being here today. Thank you so much for trusting us to bring these great topics to you, and we look forward to seeing you in the future.